get to the next thing, which is state law preemption. One of the important parts of the Title III of Regulation CF of the JOBS Act is that it actually preempts state law, just like the Regulation A, Title IV stuff that I talked about earlier. So this has been a really interesting thing over the last 6 weeks to watch how this works, because the law literally says if you're, and for those of you who are newbies to the world of securities law, all of these ways of raising money, I mean, there's really only two ways to raise money in the United States for a company, and they both involve selling securities. And I'm talking about when you're selling securities. One is that you become a registered, fully reporting company with the SEC, which means the SEC regulates everything you do. It's very expensive. You're a public company. These are the people you see traded on the New York Stock Exchange, or, in a much lesser degree than the people that are, on the OTC markets and things like that. But you're a fully reporting, registered company with the SEC. If you're not, and if you're selling stock in your company, I don't care if you're starting a lawn mowing business in your neighborhood and your best friend is giving you half the money and owns half the company, you are selling securities, and legally, in order to do that, you have to be under an exemption from the reporting requirements. The exemptions are what all of these laws are that we're talking about today. Regulation CF, private placements, all of the JOBS Act. These are all ways to be exempt from having to report to the SEC everything that you're doing. When you get into that reporting world, it's a you literally have to have certain committees, you have to have board committees, you have to give filings to the SEC repeatedly, you have to report certain events. It's an incredibly expensive process to be a reporting company. Everyone tries to stay in one of the exemptions and get out of it. All of these are exemptions. And the interesting thing is, the state law preemption part of the JOBS Act, in order to maintain this exemption, is very important, because otherwise you would have to go, the law says you do not have to go to all 50 states and register your offering before you can sell it. And the states can't prevent you from selling in their state as long as you follow the law. So you're looking at something that the federal law says to each of the 50 state securities regulators, you're out of this. You can't do anything. There is an interesting thing that's popped up in the last 6 weeks. A Regulation CF offering went up online, and immediately the state of Ohio sent a bill for $1,100 to the company that was raising the money and said, you owe us $1,100 to pay a notice filing fee in the state of Ohio because your company is domiciled here. The company went, what? The law says we don't have to. All state laws are preempted. Well, that's not the case. All state blue sky laws that involve the selling of securities and the registration of securities, and I shouldn't say selling because that's a little bit of a different story, but the registration of securities under blue sky laws are eliminated. But that doesn't mean that a state can't say, well, you have to pay a filing fee here for certain things. There are two exceptions where states are allowed to do that. One is if it's the company's state of domicile, in this case that I talked about, Ohio. Ohio has the right to charge you a filing fee. Now, Texas can't charge you that same filing fee for being domiciled in that state because you can only be domiciled in one. The second part of that is if you're selling more than 50% of your stock in any state, then they can also charge you a notice filing fee. So there's two exceptions out there that you have to be aware of when you do a Regulation CF offering. It's not going to be completely free of having to pay some money to somebody. So what are the financial requirements? This was an interesting thing that came up. Those of us who are involved in the process of making sure that we let the SEC know what needed to be in the rules and what didn't. When the JOBS Act was passed, and the text is here, and it's very interesting because when it was passed, there was a huge amount of hoopla of those of us in the business about what are companies going to have to do in order to be able to use this law. One of the biggest problems was that the law itself said, if you're a company, if you're an issuer, you want to raise $100,000 or less, all you have to do is basically file your tax returns with the SEC or some financial statements that your CEO signed off on. That's it if you're under $100,000. From $100,000 to $500,000, you had to actually go to an independent, CPA auditor who would not audit the financial statements, but do a review of the financial statements to raise up to $500,000. But if you wanted to raise between $500,000 and $1 million, you actually had to have fully audited financial records. Well, if you're a startup business and you've been in business a year and a half, and you're trying to raise money through crowdfunding, probably the last thing you want to do is go out and spend $25,000 or $30,000, $40,000 having an audit done of your limited financial records, which is what you're going to get charged to do that. So it just was a game changer to have this in there, and everyone looked at this law and said, that's going to make this law completely unworkable. SEC had hundreds of comments that came into them saying, you've got to change this part of the law. And interestingly, the way the law was written by Congress, someone was smart enough to slap this in there. It said audited financial rules, but the number for the audited financial rules, it said more than $500,000 if you're trying to raise, or such other amount as the commission may establish by rule. So the door was open for the SEC to change this law, and guess what? They did. So the SEC came in and they said, here's what we're going to do. For if you're a company and you're trying to raise under $100,000, we're going to pretty much keep it the same. You have to get something your CEO signs off on that's internal, maybe your tax returns, but it's a very simple process. If you're going to go up to $500,000, then we need to have these financials reviewed by a CPA, which is still not super expensive, but still going to cost you money. But for $500,000 to $1 million, where there was supposed to be an audit requirement, they left in the audit requirement, but then they put in an exception. They said, there's one exception. You have to have an audit done, but not the first time you use the law. So the first time you go out to raise $1 million under the JOBS Act, you don't have to have audited financials. They just have to be reviewed. So I thought it was a really interesting way of getting around the law, basically saying, yeah, we're going to make you do it, but we're not going to make you do it the first time. But once you've raised a bunch of money, we're going to make you do it the second time. It was an interesting workaround the SEC did, but it actually opened the door for people to be able to raise money, raise up to $1 million using this law, when most people thought this law was going to be completely unworkable if that was not taken out. So what are the regulatory requirements? If you're a company that wants to use this law, you want to go out and raise money, what do you have to do? It's really a pretty simple process. It was built to be very easy for people to do. There is a form called Form C. It's the Appendix C to the course materials that I gave you. It's a multi-page form, but any company CFO would be able to fill this thing out in a day. It's not a difficult process. It's the information you think, what's the name of your company, your address, names of your directors and officers, description of your business, target amount that you're going to raise. You can look through the form. I won't go through it in great detail. But the one thing that people think about this law in the infancy that it's been out here in the last, almost 2 months now, is that, well, I can just go fill this out and file it with the SEC. And those of us in the securities world who practice in this area know, anyone who's ever prepared a PPM or a prospectus or a S1 before, we know that the art of protecting, and science too, of protecting our clients is the parts of those documents where you disclose the risk factors. Number one, we get hired to make sure that what people file with regulated agencies, the SEC or what have you, we get hired to make sure that what people write down is A, not misleading, and B, that we put in all disclosures, including risk factors that could possibly come up that would prevent the company from being sued because the company disclosed it. For example, if you don't disclose, well, our product is based on certain raw materials, then these raw materials are very difficult to come by, and we have no guarantee we're going to be able to get them in a year because, some kind of boll weevil destroys whatever it is that we need to buy. Those are the kinds of things that the lawyers like ourselves get paid to make sure are all included in the form and all, disclosed in an appropriate manner. There is a big section of Form C for Regulation CF that deals exactly with risk factors. And I can assure you, and I know I'm preaching to the choir, talking to the legal community here, I can assure you that companies are not going to disclose everything that they need to disclose. They're not going to put down all the risk factors. They won't know what all the risk factors are, and if they do, they don't want to say them because they don't want it to look like, wow, there's 10 pages of things that can go wrong here. The problem they don't realize is if you don't put those things down and one of them happens, the company is going to get sued. So this Form C is not a difficult thing for most companies. They probably could fill it out on their own. But as in advising an issuer who's going to go forward, the most important role in dealing with the Form C is, as a company, is A, making sure all statements are not misleading, but B, making sure that the risk factors that are disclosed are, I personally do them the exact same way I would do them if they were on an S1, or if I were putting them into a PPM. There will be a lot of risk factors disclosed. It's going to probably take up more of the Form C than the rest of the Form C combined, but the goal here is to make sure that the company is protected, and companies don't necessarily like that. But when you explain to them that this is the way it needs to be done and these are the risks you take if you don't do it, most of them will come along, and just like when you show them a PPM for the first time, they're like, why is this whole thing about risk factors? That same conversation needs to be had, with them as you go forward.